Hello, I'm Dominic Walker, JMW's Inside Man, and I'm with Louise Wakely. Louise is a Senior Associate Solicitor in JMW's Commercial Litigation Department. Hello, Louise.
Hi, Dominic. How are you?
I'm very well, thank you, Louise. Now, I wanted to talk to you a little bit about that very first meeting with the lawyer. I know you've got an awful lot of experience at meeting with a whole range of different clients, so I can think nobody better than you to ask about it. So what are the things that a potential client should think about at that first meeting?
Well, Dominic, whether it's the first meeting you have with a lawyer or a subsequent meeting with a lawyer that you've already instructed, to get the most out of it, I'd recommend three things. Firstly, have a clear idea in advance of that meeting what your objectives are for the outcome of the meeting. For example, your meeting may be to seek advice on a particular issue. So the purpose of that, the objective of that meeting might be to discuss the background to the case and to give your lawyer the material facts. Or you may want to know what your options are for resolving a matter. You might be dealing with a long-standing dispute and you really might want to just bring it to a close. So the purpose of that meeting may be to ask your lawyer about the various potential options for resolving the case, including the likely costs, the processes, the timescales. Or your matter might actually require some urgent assistance. So the meeting may be the best opportunity to agree an action plan with your lawyer on the immediate next steps for both you and for your lawyer. Secondly, I'm a real strong advocate for the use of chronologies and to help your lawyer remember the key facts, and also to save yourself a little bit of money in legal fees. I suggest you prepare a simple timeline, which is what we'd call a chronology, setting out the key dates and events by reference to any documents and to the parties involved. It doesn't have to be overly detailed. In fact, a simple chronology is absolutely fine, as your lawyer will quite often add to that chronology as their understanding of the case develops and as the matter progresses. But what I often find is that with a chronology created at the very outset of the case, it is often used to instruct experts, barristers, mediators. It's a great way of informing third parties of the intrinsics of your case. And it's helpful for the purposes of preparing court documents, also for the purposes of resolving a dispute, for example, at mediation. It's simply a great way of informing your lawyer and other third parties of the ins and outs of your case, so that your lawyer knows your case as well as you do at the earliest opportunity. And then thirdly, really, I'd just suggest that at the earliest opportunity, whether that be the initial meeting or a subsequent meeting, you send all of your relevant documents to your lawyer, as those documents are likely to be the key materials relevant to your case. And it's especially so in commercial litigation disputes, which lay at the very, very heart of one's matter. Your lawyer, with those documents, can then assess your prospects of success, or if you're defending a matter, they can assess your likely prospects of successfully resisting a dispute. And from there, you with your lawyer can devise a strategy going forward, and your lawyer can advise you of your options.
And what are typically the sorts of questions that a client should be asking the lawyer, Louise?
Well, very much depends on each and every case, but quite often the purpose of that meeting, and especially an initial meeting, will be an opportunity for your client to ask all sorts of questions, such as, have you ever had experience of dealing with this type of dispute before? And if so, what was the outcome? What are my chances of success? And what happens if I lose? So best and worst case scenarios. How long will it take until this matter reaches a conclusion? How much is the likely cost? What are my potential funding options, if any? How can I keep costs down? There's a whole raft of questions a client could potentially ask, and there is no prescriptive list of the types of questions. But your lawyer is there to help alleviate your concerns. So really use the opportunity to ask any questions you want to. And actually, if you come prepared to a meeting with your lawyer with a list of those questions, it can often assist, because it can be very easy during the course of that meeting, in the throes of a detailed discussion, to lose sight of all the things that you want to ask and points that you wish to discuss. So a little list of pre-prepared questions can be quite useful. And really, a meeting with your lawyer is as much an opportunity for you, the client, to find out information from your lawyer as it is your lawyer finding out information from you. And if there is anything you don't quite understand, ensure that your lawyer explains it to you, perhaps in a different way, so that you do understand, because after all, a lawyer's job is to ensure that you understand their advice.
And I think the questions there are a wonderful tip, Louise. I just wondered if you've got any other tips for a client meeting with a lawyer.
Well, I'd just highlight the fact that what you say to your lawyer, whether that be person to person in a meeting or over the phone or via email, it's kept confidential. It's completely confidential. And if the meeting is for the purpose of seeking and receiving legal advice on a legal issue, then it will also be protected by privilege, which essentially prevents it from being disclosed to any third parties without your consent.
Louise, thank you so much for your time. And I know that all of the lawyers at JMW Solicitors are all very friendly. So, you can always make it out. First meeting, I've got a list of questions here. Help me out. So thank you very much for your time, Louise. And if you'd like to contact us, you can email insideman@jmw.co.uk or call 0161 82 81 999. I'm Dominic Walker, JMW's Inside Man.